Hey everyone, welcome to you all. So today we are going to understand a doctrine relating to the Constitution of India and which is also related to our Article 13 which is under Part 3 of the Indian Constitution. So in today's video we are going to simplify what the doctrine is all about, its basic meaning and what are the case law that is relating to this doctrine. So the doctrine we are going to talk about or explain about is the doctrine of severability, which is also known as doctrine of separability. So the meaning is very simple. As you can see, it is also known as doctrine of separability, means to separate, and it has one exception. This is also we will define with the help of the case law. So here I have mentioned a case law here, that is A.K. Gopalan versus State of Madras. So what happened in this case? Section 14 of the Prevention Detention Act 1950 was declared as ultra vires. So this particular act was challenged under this case. And what happened? Supreme Court has declared, sorry, the State of Madras, the court declared that Section 14 will be declared as ultra vires and that should be curtailed from the very act. And also it says the decision that Section 14 is ultra vires doesn't affect the validity of rest of the case. So let's go back and know what is in Article 13. So Articles 13 explicitly talk about that any law which will be against the fundamental right can be made. In under Article 13 Clause 1, we got to see that Article 13 Clause 1 deals with pre-constitutional law. Before the 26th January of 1950, the laws that were there, they were considered as pre-constitutional law. And what about if they are inconsistent or is against the fundamental right? Will they all the whole act will be declared as void? Declared as void? That is the question. So on this regard, the court has come up with this doctrine and said that if there is an act and only one part is against the fundamental right, as so in that case we can cut off the part which is against the fundamental right and rest we can keep it as it is. So let's now simplify it with the help of this picture. As you can see, this is a picture of a hand and this particular part is a kind of a tumor that we have. So this is you know giving us trouble in doing our day-to-day work. So what we can do, we can remove or cut off this part and we can go with the formation of the hand as it is. So if we cut off this part, it will not affect the whole formation of the hand. So this way we can simply just cut off which is in conflict with the fundamental right, and rest we can go as it is. So that is the doctrine of severability. Again, it has some exception to it, which we will again understand with the help of other case law. So let's move towards the other case. So again, RMGC versus Union of India is a very important case of this manner. In this case, the doctrine was elaborately discussed and the points, there are many points that has been given. So we will here just understand 2 points, and with the help of these 2 points we will be able to understand what the doctrine of severability or separability is. So the point says, if the valid and invalid provisions are so inextricably mixed up that they cannot be separated from one another, then the invalidity of a portion must result in the invalidity of the act in entirety. So it says that if there is an act and all the provision, all the section are mixed up, and if we cut off any particular provision, that will create problem for the whole foundation of the act. So in that case, just because the whole act without that particular provision can't be operative, in that case we need to struck down the whole act as a whole. That is the exception that we have. Then on the next point it says, on the other hand, if they are so distinct and separate that after striking out what is invalid, what survives can stand independently and is independent of the rest, then it will be upheld notwithstanding that the rest had become unenforceable. Again, it says if a provision is separate and is not causing any kind of link to the other provision of the act. In that case, we will only separate that part which will, creating conflict with fundamental rights. So that way we can, cut off that particular part only, and we will accept the act as a whole after excluding that affected part. So now we will understand it with the help of an example. For example, there is an university and there are certain rules under which university should be, carried upon. For example, it has syllabus, it has principal, it has the rooms. So these are some kind of rules, guidelines, or such kind of thing that is needed in order to run a university. And there is also, as we can say, under 3, the point was given that any person having a black skin color will not be enrolled under the university. Again, this is discriminatory of Article 15. So Article 15 talks about there shouldn't be any discrimination on the ground of race, caste, religion, and sex and place of birth. So Section 3 is, against our fundamental rights. So we can, you know, challenge the act on the basis that Article 3 or point number 3 is against the fundamental rights. So in that case, we will remove only that particular part and we will release the other guidelines as valid and will be applicable to that certain thing. So this way we can understand the doctrine of severability, which is relating to Article 13 or pre-constitutional law, that is Article 13 clause 1, and these are the two very important case laws that we need to remember. In this case, various points have been given on what basis we can cut off the whole act, on what basis we can cut only that particular area. So this has been mentioned on a elaboratively manner on this case. So now let's understand it again in a simple manner. As I said, if we are having a particular tumor and if the other part of the hair is inoperative, so we will just simply cut off that particular area and rest we will keep as it is, because we don't need to do any more changes to the foundation or the structure of the hair. So what about if we are having some issues with the heart? Can we remove it from the body and say to the body to function? No, because it is mixed with our whole body. It is a very important and integral part of our body. If we remove or do anything relating to it, our whole foundation will be struck down. We won't be able to do any work. So in this manner, what happened? We need to remove the whole being, because this affective part is mixed with the other part of the body as well. Therefore, we cannot simply cut it off to run the other stuff. So here, as you can see, this is not linked with any other stuff. So here, removing the part and keeping the other stuff as it is will be easier for us. Unless here, it is very complex manner and we cannot do anything relating to it. We cannot separate the heart from the human being. So this way, here comes the doctrine of severability, or to separate which is no longer serving us in a good manner and which is against the fundamental right. So this way I have tried to explain the doctrine of severability in a simple manner possible with the different case law. So in our next video, we'll try to cover up the other relating or other important stuff as well. So that's all for today. We hope I have made it clear and understanding. And thank you for watching the video.